So what does it not do? And that's very important. It does not validate anything which has happened earlier. One, there is no question of merger. Number two, and that's my respectful submission. Now please pick up, because before I go to section 4, please pick up the Attorney General's submission. Only 2 paragraphs. And those are para 2.5.3 and 2.5.4. This is what I am addressing now in all this submission. Please go to 2.5.3. This is the additional submissions of the Attorney General. If it's the same copy that I have, it should be on page 11. Only 2 paras I'm going to read. It's a para beginning nevertheless.
2 point?
Well, it's titled additional submission.
Page 11.
Yes, and it's handed in on the 5th of December.
This was the main argument for advance
smaller
on
parties in the party.
Yeah.
The nominated members, the independent members, and members who represent the smaller numbers in the party. Their party may be bigger outside, but their numbers will be lesser here. So you said that time should be distributed to all of them. And that was
Your Lordship, sir, correct. So now just let's read it.
consolation to all of us.
Nevertheless, the submissions advanced by the petitioners carry no weight, insofar as they fail to appreciate that even in the present case, the government exercise of powers under 26(2) has been incorporated by reference. Please mark that. First legal concept, incorporated by reference into the specified Banknote Cessation of Liabilities Act 2017, and therefore the same was effectively been validated by an act of parliament as well. So this is the second legal concept in this one sentence, 2.5.3. Incorporated by reference, validated into an act of parliament. 2.5.4. The notification of 8th November 2016 has been affirmatively referred to in section 3. By such affirmation, Parliament can be said to have taken into account the notification and its implementation scheme. As a result, since the notification has, now this is the third concept, merged in the parliamentary law, it has ceased to exist independent of legal instrument. It has ceased to exist as an independent legal instrument. It must be taken that regardless of any issue relating to the exercise of power under section 26(2), the decision to withdraw existing CDs of certain denominations from legal tender must be treated as a parliamentary plenary declaration. So there are 5 concepts, maybe there are more. Incorporation by reference, validation, merger, cease to exist. The notification itself has ceased to exist as a legal instrument, and parliamentary plenary declaration. Now, I am going to respectfully submit very quickly that each one of these is incorrect in my respectful submission. First of all, I would respectfully submit that this is muddling up all sorts of legal concepts which can't be muddled up in these 2 sentences. So let me specify. First concept, incorporation by reference. Incorporation by reference is a concept, is a legal concept which this court regularly applies, where a statute doesn't want to repeat all the statutory provisions again and again because they are already contained in another statute. And therefore, it makes a reference to that particular statute. And then there's a whole body of case law as to whether amendments to that other statute get incorporated here or not. That is the concept of incorporation by reference. Here, there is no incorporation of by reference. There is certainly a reference to the other notification which was in the executive realm. This ordinance is dealing with legislative power, completely separate and distinct. Second concept, validation. Validation arises when something is declared ultra vires. It may be ultra vires for a variety of reasons. There's no concept, no court had said that this is ultra vires. No one at that point of time requiring validation. In any case, 26(2) is an executive power, doesn't confer any authority on parliament. There's no question of validation. So that's my second answer. Third concept is merger, merged into parliamentary law. My respectful submission is this is 2 distinct things. One was an administrative action under 26(2), another was an extinguishment of liability under 26(1) and 34. There's no question of merger. The fourth point is ceased in law, it has ceased to exist. I think this is, well, I don't think this is even stateable, frankly, except that the Attorney General has stated it. It had its life. It had complete impact across the country. And it had full force of law, subject to, of course, what your lordships now hold. It had the full force of law. And it operated
But
immediately on being issued on the 8th of November 2016 until the 31st of December when there was a period, but it ceased to have any legal tender basis. So this to say that it merged into a statute is again, in my respectful submission, ceased to be an independent. It continues as a legal independent instrument. The bullet has been fired. It has, in the form of the notification, it has carried its course and it has done what it has done. It doesn't cease to it. It doesn't have any impact or effect later on because it was self-contained at a certain level. But legal tender immediately stopped. And finally, it must be treated as a plenary parliamentary declaration. I don't think any plenary parliamentary declaration is made or even attempted to be made by this one. So that's my respectful submission. Now now we come to section 4. Now before we come to section 4 of the ordinance,
How can it
But-
be given that
Thank you very
by a
much.
plenary parliamentary declaration?
yeah, there is none.
No, a specific statement is made that from 31st of December so and so,
Yeah,
all these specific bank notes shall cease to exist.
yeah,
And the guarantee and the promise
absolutely right.
shall cease to exist.
So just see the please, it's two different things, my lords. Where's the question of merger cease to exist? Please, what the ordinance does is it extinguishes. Sorry.
What has been done
Yeah.
under the notification of November,
Right.
what was provided was that
Legal tender.
it shall cease to effect on legal tender.
Correct.
It granted a window till 30th of December to exchange the notes.
What does that mean? The guarantee was still there.
Guarantee was there.
Yes. Why was it there? Because that's why you could exchange notes.
And therefore, because they,
So-
you see the fourth,
No, no, but may I just, sorry, with your permission.
you see the fourth whereas.
Yes.
And whereas it is necessary to have clarity and finality.
Finality, yes.
The parliament might have thought that there might be some ingenious arguments and therefore to take care of that.
No, this actually,
The specific ordinance.
yeah. So I'm actually obliged to your lordship's question because I think it answers the earlier issue which I
Your
sorry.
argument is to be accepted.
Yes.
It will have so much ramifications because under the 1778 Act, there is no such declaration under section 26 and 34. And those 10,000 notes will still have to be honored and by the government.
Sorry. No, so let me just, Manoj, I think part of it is answered, part of it is answered. The fact that the guarantee and the liability continue on and after 8th of November 2016 is now I'm supplying two more reasons. The first reason is, it's clear from the fact that they exchanged notes. That's reason one. And the second is,
And the notification itself provided.
yeah, of course, because of a guarantee which was extant and outstanding, and because there was a liability which was extant and outstanding. That's the reason. But there's another reason. The second reason is that you could not have an executive direction which invalidates a statutory obligation under 26(1) and 34. That's the elementary proposition which we are canvassing. Of course, there may be some subtle argument under contract law, but the legislative argument is, or the administrative law argument is, or the constitutional architecture argument is, that you cannot have executive action nullifying a statute under the very statute under which the executive action is issued.
I will repeatedly say that even if you accept your argument,
Yes.
November notification.
Correct. So now now I'm only on that. Now I'm only on that.
Under the same notification also the deadline was
Yes.
the same and under the ordinance also the
All right. So now let's answer that. Now we are focusing on that. Now we are focusing on that. So first, your lordship,
विशेष प्यार और विशेष स्नेह
of grace period.
हमारी
Are you
छोटी
trying to
पार्टी और
say-
Yes,
सदन
sorry.
के
Are
छोटे
you trying to say
सबसे
that
युवा
because of the
सदस्य होने के नाते
guarantee
मेरे प्रति
which
रहेगा, सर,
continued,
आपको
Yes.
इस
that there was
नई
provision
पारी के
made
लिए
for
ढेरों
exchange of
शुभकामनाएं।
notes.
Absolutely.
And the banks
Those whom I love and
Absolutely.
respect.
see,
They
they
suffered the
ultimately,
most.
because the banks accepted the notes which ceased to
Dr.
be legal tender and they
Sashmit
gave
Patra.
valid notes, the new notes.
माननीय
Otherwise,
अध्यक्ष महोदय,
The banks had no duty to exchange the notes which the central government had said had ceased to be legal tender.
That is absolutely my point. My point is that the guarantee and the liability continue.
The provision for exchange is a continuation of the guarantee.
Absolutely.
The guarantee is extinguished. You may say that.
No,
That is my very submission. Malad, let's be clear. Malad,
provision for exchange.
Yes, sorry.
In the notification.
The provision for exchange is a
माननीय
continuation of the
मुख्यमंत्री श्री
primary
नवीन
liability
पटनायक
itself, not
कोई
just
नहीं दिया।
the extent of the guarantee.
Government guarantee.
हमेशा से एक
No,
चीज
the liability, the
सबको
RBI
कहा है,
itself continues.
34.
जब भी संसद में
Therefore,
जाओ
the notification
मर्यादाओं
did
की
not
रक्षा करो
extinguish the liability.
और संसद उचित तरह से
8/11
चल सके
2016
इसका
Would
पूरा
not.
पूरा कोशिश
because
करो।
they said the
तो
window
ये
is
अवसर
open
मैं
for
लेना चाहता हूं
exchange.
मान्यवर
Unless if
आपकी
suppose the liability is
अध्यक्षता में,
wiped out on
आपके
8/11, they can't re-exchange the notes.
इस सदन में
Therefore,
जो गरिमा है,
that is the reason
उस
why the
गरिमा को
liability
रखते हुए
continued.
हमारे माननीय
Legal
नेता
tender
श्री
also
नवीन
only
पटनायक जी
ceased
के
to exist.
मार्गदर्शन में जो हमने सीखा है
The liability,
उसके
otherwise
साथ हम
they
इस
would not have
सदन
Not just the
accepted.
guarantee, not just the guarantee,
Accept
but the
the
liability.
चलाने में
The
आपका
bank
पूरा
just the
सहयोग
guarantee.
I am in 100% agreement with the
मान्यवर,
observation made that on and after
मैं ये
8th
अवसर
November,
लेना चाहता
according to
हूं ये
me,
कहने के लिए
the liability
that you are
continued, the
distinguished
guarantee
man of
also
law
continued, both
who is
continued.
presiding on the
Eventually, as
highest
Justice
house
Gawai
of
has
law.
correctly pointed out, extinguished
And as a
on 31st
distinguished
December
man of law,
2016, subject to judicial review
presiding
by
over
this
the
court.
House
But that
of
is the
Law
scheme which was followed.
आपकी
So that
जो
is why,
rich
Manoj, I'm
experience
obliged for that question.
जो
The
vibrant
reason
है,
why they were obliged,
वो हम
apart from
सबको
being in
एक
terms of
अवसर
the
देगा और
notification
सीखने
itself, there was an outstanding
माननीय
statutory
कई
notification. Your
माननीय
lordships have
सदस्यों
noticed
ने
my point.
आप
Being an
के
executive,
बारे में कहा,
so the
मैं
tail
आपके
can't.
विशाल हृदय के बारे में दो शब्द कहना चाहूंगा मान्यवर कुछ ही दिन पहले मैं अपने परिवार के साथ सदन में आया था और सदन बंद था तो उनको घुमाने लेके आया था
For the power coupled with duty. Now,
और
for
जब मैं
that,
घुमान लेके
let us
आया
go to
यहाँ
page
पर, तो मुझे
44.
सुनने में आया कि
Because
आप
what
लंगर में
I'll just
आए हुए
indicate
हैं।
what has happened here. I'm now responding.
स्वाभाविक तौर
See,
से
I thought it
आप
was fairly
अध्यक्ष हैं,
insensitive, but I mean, we
माननीय
can't use
उपराष्ट्रपति
stronger
जी हैं,
expressions than that. To the,
appointment
describe
किया
the
जाता
attitude
है,
of both the
protocol
Reserve Bank
किया
of India and
जाता
the
है,
Union
और
of
उसके
India.
बाद आपसे
So
मिलाया
these
जाता
are
है।
genuine
क्या
cases.
हुआ
What
मुझे
are you
लगा,
going to do
आपसे
about
मैं
it?
मिला, एक
Now
दो
please
बार
see
मुझे लगा कि
44
नहीं।
first. Go
मैं
to
माननीय
page
अध्यक्ष जी
44.
को एक
Now this is what they
भेजता
do
हूं
on
कि मैं
30th
अपने
December
परिवार के साथ आया
2016.
हूं। क्या मुझे 30 सेकंड आपके
Now
बीच
I am relying on a
माननीय
part of this
अध्यक्ष महोदय,
notification.
आपका इतना विशाल हृदय
And
है
I am going to show
कि
your
आपने सिर्फ
lordships 2-3
दरवाजे नहीं
ways
खोले,
out.
आपका दिल का हृदय खोला, पूरे
we are
परिवार
right.
को अंदर बुलाया, चाय
Please go
पिलाई,
same
गपशप करी
compilation
और मेरे
1.
बच्चों को
Please
भी
go
आपने
directly to
inspire किया।
44. Now
ये
just see the
बताता है
first
कि
part.
किस तरह से
In exercise
आपका
of
हृदय
powers conferred under
आपकी
clause B
सोच
of subsection 1 of section
सिर्फ
2,
सांसदों के
read
लिए
with
नहीं,
clause 1
उनके
of subsection
परिवारों
1
के
of
लिए है।
section 4
और
of
आपकी
the
जो
specified
विश्वास
notes
है
that's
कि किस
ordinance,
तरह
the
से
central
आने वाले
government
दिनों में
hereby
इस
specifies
सदन को
in
और
respect of
आगे लिया
citizens
जा
of
सकता
India
है।
referred to in
ये
clause so and
इसका
so of the
एक
set.
प्रतिबिंब है।
So this is issued by
मान्यवर,
the Ministry of Finance. Please note that this is not an RBI
आपने
notification.
तीसरी
It's a Ministry of
advisory
Finance,
committee में
Government of
बहुत
India
खूबसूरत
notification.
बात कही।
Now see
मैं शांत
this,
होकर
I am
सुन
quite
रहा था।
happy with
आपने
A,
कहा that whenever
who
there is
is a
any
resident
matter,
of India. So they are
I'll
specifying the
first
grace
look to the
period.
opposition,
Who is a
then
resident
I'll
of
look
India
to the
for the
government,
period ending
and
31st
then
day
again
of
I'll
March
look to the opposition.
2017,
That
and
shows
B,
the strength,
who is
that
not a
shows your
resident of India.
commitment,
This is what
that shows
covers
your
me.
vision
A
of
period of
running the
30th
house.
day
And thank
of
you for
June
that.
2017 as the
मान्यवर,
grace
आपकी
period
बात
for the
कहूंगा।
purpose of the said ordinance. Now, so
ये
far,
सदन
I am
काउंसिल
in a
ऑफ
very happy
हम
situation
उड़ीसा से आते हैं
because it's still the 30th of
और
June
कई ऐसे
2017.
विषय
I'm in a
होते हैं
KYC account.
जो
I've got the
सदन में
money, this,
states
that,
के
and the
बारे
other.
में
There's no
चर्चा
problem
होती
at all. All right, this is one aspect.
मान्यवर, जब प्राइवेट
Now they have
मेंबर्स
a
की तरह हम
proviso.
लोग आते हैं
So there
हमारे
are two
COR
ways
आते
of
हैं,
reading
हमारे
this
स्पेशल
proviso.
मिशन
First,
आते
let me
हैं,
read it
कई
and
बार adjourn हो
then
जाता है,
make the
खुल जाता है
submission.
मान्यवर।
Provided that
तो
the
एक
amount in the
अपेक्षा ये
specified
है
notes
कि हम
rendered
जो
does not
इन
exceed the
parties हैं,
amount specified
हमारे
under
पास ज्यादा
Regulation
scope नहीं
3
होता
or
bill को
Regulation
चर्चा करने
8
के लिए।
of Reserve Bank
तो ये जो
of the
0
FEMA
hours रहते हैं, special
dated
mentions रहते हैं,
29 December
अगर इसमें कोई
2015
प्रावधान
made
आते
under
हैं,
provisions of
जिससे
the
कि
Foreign
regional
Exchange
parties
Management Act
जो
and the
state से
conditions
चल के आती
specified
हैं,
therein
इस
are
council of
complied
states
with. Correct? This is
अपनी
the
आवाज
proviso.
को और रख सके।
Now,
ये
first
council of
submission.
states का जो सोच है, उस सोच को और
This
गरिमा दे।
proviso can only apply
आगे
to
मैं
people
सिर्फ
who
यही कहूंगा,
during
दुनिया में
that
दो शब्द
period
कहूंगा
were out
कि
of
आपनों
the
को
country.
अनेक अनेक स्वागत,
That's one.
अनेक
I am
अनेक
not there.
अभिनंदन,
I
आपनों
was in.
समस्त
I was up for
शुभेच्छा,
it.
आपनों
It
को
can
सहित
only be
रहिछि,
apply. My mistake.
आपनों को
It
सहित
can
रहितो,
only apply to
आपके
people
साथ
who
हमारी
carried
शुभेच्छाएं हैं,
currency out of
आपके
the
साथ
country.
हमारा
Who
अभिनंदन
carried
है,
currency
और
out
हम
of the
आशा करते
country
हैं आपके
and who were
मार्गदर्शन में
away.
हम और आगे बढ़ेंगे।
The
बहुत बहुत धन्यवाद।
proviso. Well, see, please see. Who is resident in India for a period ending 31st day of 27 and who is not resident 30th June 2017. So I am saying let us go by this part of it. It will be enough. It gives me relief. There's no problem. Because I landed well before 30th of June 2017. In February itself, I tendered my money in one case where, so there is no problem. And insofar as for people who are out of India, correct? So there's no problem. Now, what is the effect of the proviso? The proviso restricts it to someone who carried an amount abroad and brought it back. Now, I was not in that category. My money was lying in India. So, therefore, the proviso has no application. So, this is one way, your lordships, can grant relief to citizens who had left the money in India and were away from the country during that period. What is the method? The proviso does not apply to people who had left the money in India. That will give a huge amount of relief to people such as myself, people such as who Mr. Rao was representing, etc. Sorry.
What would be the mechanism?
No, it's
No, to find out that those non-resident Indians had genuinely kept the money when they were traveling out.
so they have to be satisfied. That will be on a case-to-case basis.
Notification are for two classes.
Yeah.
Insofar as persons who are residents in India, there is no such restriction.
There is.
No. If there is subsequently it is clarified.
No, we'll come to that. Manoj, your lordship is right. There is that clarification which I'll deal with.
For
separately.
resident
Yes,
Indians,
yes.
there is no limit.
Yeah,
There is no requirement for declaration.
correct.
Then the proviso is applicable only those persons who are NRIs.
Right, so how? So if, what about an NRI who has left it in India? Well, I mean, that's like, can you imagine what a huge group of people that is?
But even NRIs don't have a restriction.
Sorry?
Even NRIs don't have a restriction up to 31st of December. The rest
We are talking about grace period.
Then Mr. Young said, so asking them to return at before 31st of December.
is unreasonable, manifestly arbitrary.
Yes, it is manifest or extraordinarily cold-hearted.
Maybe the tickets would have costed them more than 1.5
Millard,
lakhs.
what was he doing for these 2 months when the notification said that he will get this opportunity only till 30th? Can he say that he can
It's an
enforce?
astonishing submission.
Can he say that
It
he
is the most callous submission on behalf of RBI.
merely
To make
use the word
submissions
callous
like
will
this,
not help?
गवर्नर का जो काम किया है बहुत बड़ा वहाँ चैलेंज था वहाँ काम करना बहुत बड़ा मुश्किल था लेकिन आपने
So according to him,
Yes.
this has to be linked with right to life. Right
और
to,
बंगाल
he has the right to live with dignity and
Yes.
therefore he is not expected to come back for this party 1.6 lakhs. When the tickets itself would have costed him more than that.
Millard,
No, it's much more. Actually, it's much more than that. I will explain that.
he has come back in February. He could have come back in November. Millard, the question is whether no opportunity was given to him or not.
We have noted your argument yesterday that 31st of December,
Yes.
everybody had opportunity to do away with everything.
Everything.
Now, let me just deal with this argument right now. This is a wrong submission on facts which is made because until the 30th of, so please note this now. Until 30th of December, the assurance given by the Reserve Bank of India and the Prime Minister of India, no less, was that you will have an opportunity even past that date. And I'm going to point that out.
Millard,
And it's only on 30th of December they said there's a hard stop on 31st December. Is that reasonable?
Millard, this is a rejoinder. Millard, it is very difficult for me, Millard, to collect all this material and give it to your lordship today. So I'm Millard, the ones which are obviously incorrect, Millard, please permit me to point out. The notification said that exchange will be permitted only up to 30th December. So this argument that Reserve Bank said that he will get after 30th December, that the Prime Minister said that he will get after 30th of December, all this is not irrelevant. The notification which is the law said 30th December. He knew that.
When did that notification come?
Lord, 8th of November, this is the first notification.
Oh, you're referring to-
First notification.
No, there was another notification of 30th of December.
No, the
Yes.
I'm sorry, Millard. 30th December, Millard, is grace period notification. But Millard, there is a primary notification which gave them the right to exchange whatever they wanted to. And Millard, the answer to your lordship's question as to why would banks honor after Millard 8th of November is because the notification said they will honor. Millard, the notification said so. They will honor under these circumstances from the beginning.
That is
So it's the law.
Central government has guaranteed the currency.
Millard, it doesn't matter whether they
Liability.
Millard, it doesn't matter whether there is a liability, it doesn't matter whether there is a guarantee. The notification says. All right, very well.
Now let's just get rid of this point because I mean I find it in plain English, but anyway, go to page 27. Let's just answer this point. Just go to page 27.
मौका दीजिए दूसरे दिन एक्शन होना चाहिए और हाउस का काम भी मतलब चलना चाहिए इसीलिए आप एक सर्वोच्च हाउस के आप चेयरमैन बन गए हैं, इसीलिए मैं मेरी जो आरपीआई है रिपब्लिकन पार्टी है,
Paras 9 and 10 first.
So already read it to us.
इस पार्टी की तरफ
No,
से
but
मैं
then
आपके
it's being
साथ
said
हूँ।
over here that on
पहले
8th of
से
November.
आपको
Now
साथ
look at
दूंगा
his statute.
और
Look at the
बाद में
statutory
बोलने का
notification
मौका
issued by the
दीजिएगा।
ministry.
जय हिंद।
Please see
जय
this
भारत।
clause 9. Why is the statement being made contrary to the statutory notification?
Dr.
On page 34.
Keshav Rao.
Look at clause 9 on page 34. Any person who is unable to exchange and deposit the specified banknotes in their bank accounts on or before the 30th of December shall be given an opportunity to do so at specified offices of the Reserve Bank of India or such other facility until a later date as may be specified by it. So this is the government of India making an assurance to all people. And I'm told just now that on the 30th of December, I should have bought a ticket which brought me back into India by the 31st of December.
How did you read?
I mean, this is an astonishing submission by the Reserve Bank of India, contrary to the Ministry of Finance statutory notification.
How do you?
So the whole scheme is that if the Prime Minister says it, the statutory notification says, we are not going to take away your money after 30th of December either. This is what even after 31st of December, till 30th December was given time. But this is a statutory notification on the basis of the Prime Minister's statement. And you suddenly change the goalposts on the 30th of December and you say that now we are not going to do it even if you're abroad. What was I to think when I was overseas? Apart from the points which your Lordship correctly put to me, what I was to think was that, look, this is a reasonable government. I have a constitutional right to property. I have my money which has been withdrawn and which is lying at my home. I'm not required to rush back and spend whatever amounts which are there, provided I get a ticket. I will come back. I came back in February. Now, please go to the statement, therefore. So, one part which I'm suggesting now, I'm suggesting to the court that this proviso at page 44 applies only to currency gone out if there is a case made out of a person who has left the currency in India. It ought to be accepted because the proviso has no application. That's my first submission. So please clarify that. That will give a lot of relief to a lot of people. The proviso obviously applies only to people who go out of the country and who come back. That's one reasonable interpretation which can be given. I would respectfully submit. I would commend it to the court. The second reasonable interpretation is, now please go to bottom of page 47. These are the RBI guidelines. Where do they get this from is the question I ask myself. For non-resident Indians. Now, please see. So there is para 3.4 at the bottom of page 46. Your Lordship, see second last line on 46 is 3.4. Please note that my relief which I sought was strike down this insofar as it applies to me. Now in 3.4, the terms are specified, and for non-resident Indians, tenders should be submitted along with the tender form, Roman 2, Roman 3, tenders will be restricted to a maximum of 25,000 per individual, depending on whose notes were taken out of India. So again, my submission is, all these requirements of certificate of Indian customs on ascertaining that the tenderer was abroad and had a KYC, please interpret this particular set of directions given by RBI as confined to people who took currency abroad, but it is silent on people who left currency here. And I think, in my respectful submission, I don't know, I suppose jet-setting lawyers can go up and down the country and buy a ticket immediately and come back, etc. But I think the government of India adopted a very reasonable stand initially when they kept it open because they were respectful of rights. And to answer Justice Gawai's question, I think the presumption has to be that citizens who come and who have genuine cases, if they are able to explain it on the strength of an affidavit, is bona fide and on the basis of passports, etc., and there is no history of them being a history cheater or something, should be presumed not to be a terrorist, someone engaging in trafficking or counterfeiting. I mean, these are amounts which are a huge amount for the individual himself or herself, and to be just. So therefore, I come to the point that this exclusion in the RBI, so that's the next route which your Lordship can follow. Clarify the notification of 30th of December. Another route can be clarify that this RBI notification applies only to situations where currency was taken out and brought in. For those who say that the money remained over here, they must be given an opportunity. Otherwise, it means that there's a huge class of people. Now I'm in terms of the notification. It's a huge class of people unfairly excluded from the process. And it is no answer to say that you had 50 days to come back to India. It's no answer to say. This is a very patronizing attitude on the part of the RBI that, look, I will issue a notice. And how could I? The submission made was hope of extension. There was no hope of extension. My rights were not founded on a hope of extension. They were founded on the basis that the Prime Minister and the statutory notification issued by the Ministry of Finance on the 8th of November both said that there will be avenues available to you even after 30th of December. And it came through. So why exclude me is the question I asked myself. Such exclusion is completely heartless and completely arbitrary, is my respectful submission. Now please go to section 4. Now I'll wind up on section 4 and then a few other small points. Section 4 at page 40, clause 4 of the order, page 40.
सफलतापूर्ण आयोजित होगा और
So does your duty to cover, your duty to have an appropriate notification, does it not extend to situations like us? That's the question. Power coupled with duty, 4.1. Notwithstanding anything contained in section 3, the following persons holding specified banknotes on or before 8th of November 2016 shall be entitled to tender within the grace period with such declarations or statements at such offices of the Reserve Bank or in such other manner as may be specified by it, namely, please go to Roman 2, such class of persons and for such reasons as may be specified by notification by the central government. So my first submission is, excluding a category of NRIs who had money in India is arbitrary in our respectful submission. It is so manifestly arbitrary that it is under-inclusive, going under the traditional classification test. NRIs form a single class. Some carried the money out, some left the money here. Both have to be treated similarly. You cannot create an artificial barrier or an artificial subclass and extend the grace period only to people who carried money abroad and didn't and declared it in the customs, etc. when they came back. So it is under-inclusive, is my respectful submission under the classical test. It's manifestly arbitrary to exclude us as a whole category. Apart from the other categories mentioned by Justice Gawai, there's so many people who may be medically unable. There is another person over here, for example, whom Mr. Prashant Bhushan represented, Sarla Srivastava. Her husband had died in 2016. And in 2017, January or February, what was it? January, when she was cleaning up some trunk, or what is the correct expression? Steel trunk. She was cleaning up a steel trunk. There was money which was discovered, 1,79,000. It's a lot of money for her. Her husband had died. Now, this is in January, and she wrote to the Prime Minister and said, please help me out, which was referred to here and there, and then now she's in court. And this, therefore, is a very, so that exclusion for genuine and hard cases, I would respectfully submit, puts an even higher duty on the government to be sensitive to such cases and to create an appropriate subsection. So my submission is, central government is wanting in its duty. The second submission is that subsection 2 is in any case a standalone provision. Your lordships have said that we prima facie, I mean at the opening, not after, before hearing, felt that look, this is something power coupled with duty which even the RBI can exercise, but RBI has also acted in a manner which is incorrect. Now I'm done with this section 4 part also. Now 2-3 small points remain. The first is on judicial review. And I want, so I'll just sum it up. There appears to us to be a yawning gap of persons not covered. A huge gap. I've indicated 2 or 3 situations. There ought to be at least some broad categories to capture genuine cases such as this. So one part of the argument is yawning gap. The second part of the argument is in any case grace period has been extended to all NRIs till 30th June. Why deny it to me? Just because I kept my money here. That's the second broad argument. Now I'm on judicial review. Judicial review, your lordships know, have been held to be part of our basic structure of our constitution. There's a whole bunch of series of Supreme Court constitution bench judgments on this point. Now, what's the issue over here? Judicial review is being disabled at two levels, and I would respectfully submit, you please, your lordships will have the time to reflect on it and to decide what the correct course of action is. Just take a hypothetical situation. I'm not saying this is the situation here. Supposing under 26(2), the government had handed over minutes and agenda notes and notice and recommendation. And in this hypothetical situation, supposing all four of them were blank sheets of paper, what would the court say? The court, does it have a power? The question I'm asking myself is, the part of judicial review and your lordship's oversight, judicial review oversight, limited as it is, surely extends to an informed decision on parts like this. And an informed decision can be arrived at on an issue like this in exercise of your power of judicial review. The request is, don't diminish the court by allowing them to keep these documents, which are not some high security documents. They are administrative documents. They must be, they ought to be disclosed. They ought to be perused by the court. Why? Because it reduces and diminishes the power of judicial review. So please consider that facet as well. And I would be greatly obliged. I think the part on guardrails and to lay down defining parameters is an aspect which survives apart from individual cases like mine, where there may be 1,62,000. I believe it's an imperative. We are way past the stage where you can have some diktat issued by some ruler or something like that and say that what I say is final. No, it is subject to being reasonable, fair and just, whether it is statutory or otherwise under our constitutional scheme. So how is this power of judicial review to be exercised unless these basic documents are made available to the court? So I would respectfully implore the court that please also, as far as guardrails are concerned, and what are the parameters, whatever appropriate expression your lordship would like to use, please use it. The other element is on the question of academic. Your lordship correctly said that your lordship yesterday itself, in the course of Mr. Chidambaram's submission, said that the Bomai case is surely an answer to a situation like that. But there's a useful passage in, the Attorney General referred to a New York Court of Appeals judgment of 25th of September 1877. One of the judgments cited was a New York Court of Appeals, 25th September 1877, in the People versus Amos Clark. And it had a very good line. And I think the reason why the Attorney General probably submitted this was to show the importance of this principle, which was laid down in this 1877 judgment, and how it ought to commend itself to the court. The test laid down by the New York Court of Appeals was, can effectual judgment be rendered? And I believe effectual judgment can be rendered on the overall parameters and on individual cases such as those which have come to the court. So this issue is far from academic. My final point, so it's not moot as has been suggested. Now my final point is that we have submitted written submissions, which your lordships may take note of. It's a written submission on behalf of the applicant. The title has Malvinder Singh in it. It's a fairly detailed set of documents. These were prepared at a certain level before the arguments concluded to give our overall. But your lordships have been very kind and indulgent, and I'm very grateful for a very patient hearing. Yeah, you may consider, therefore, there's one aspect, sorry. There's one last aspect which you may consider. And it's really in the exercise of this court's power. It has nothing to do with the state. I'm now not on what their conduct is or what their actions are. I'm on this court. What did this court do? Your lordship recalls that in the opening I pointed out Justice Kehar's bench had given them a notice that, look, what are you planning to do under Section 14? Your lordships also recall the consolidating order which blocked everything from other courts. Now, let's pause here for a moment. On an issue like this, you might have certain issues where you block access to other courts, which are few and far between. But I think we will all agree that as far as value of currency, your property being taken away without authority of law, etc., all these are aspects which affect each across the country. Now just consider, when the court blocks 226 remedy, which we have all grown up and we all know is an inexpensive remedy available locally. Locally in the sense it's available in your state, right there at the state capital or at the seat of the High Court or the bench. Now when you're blocking it, I asked myself, and this is what arises here. Effectively what is happening is that only people who can do two things, who have the wherewithal to contact a lawyer who's willing to do it pro bono in Delhi and in the Supreme Court. That's a hard ask. It's a hard ask for citizens, most of us. I was asking myself sometimes that, look, can I find a lawyer despite being in the profession in most parts of the country? I can't in a short while do that. And someone who will do my case, with reasonable competence and free of charge may be very difficult. So I am suggesting to the court that yes, I am primarily concerned with Mr. Malvinder Singh, and Mr. Bhushan has appeared also for Sarla Srivastava, and your lordships may peruse the facts. But having nothing to do with the other side, but having to do with your lordship's own order. Having blocked access in all these courts across the country, would it not be desirable for this court at this stage, if you agree with any part of our submissions, to direct that a scheme which is more general in nature than just for me? I'm not saying that they are obliged to do it. But because your lordships blocked everyone from going, how many have come forward? Very few. Isn't it now a corresponding duty ex debito justice? If you agree with our submissions or any part of it, that if relief is to be given, it ought not to be only to Malvinder Singh and X or Y or Z, but it may be for a time frame, but more generally, not because the law requires it, but because your lordship's order blocking access elsewhere perhaps requires it. I'm very grateful. Thank you.
Yes, where is the party in person?
Sir, as per section 21.5
Party in
of
person.
Rivhan
Madam, you wanted to say something?
operational guideline of Pradhan
Be
Mantri
brief.
Fasal Bima Yojana.
But it's a rejoinder.
Like hailstorm,
I know your lordship. I'm just saying 2-3 points, that's all. First of all, I'm appearing.
natural fire due to lightning have been included under risk scenario of localized calamity.
This is the other issue.
However, section 21.5.10
Your lordship, my first
Laws
submission
to
is
crops
that,
like
first of
paddy,
all, we were not
sugar
allowed
cane,
from 9 to
jute
14
and
because we
due to
were
inundation
having,
are not
we were
included
not individuals,
as
your
they
lordship.
are
We were having a
considered
society account.
hydrophilic
We were not
crops.
allowed to deposit
This
in
No,
provision
we are
is
not
not
considering that cases.
rational.
That's
We are
all.
considering those cases.
Longer
Just
duration of
some brief
inundation,
facts only
especially
for
at
your
critical
notice.
growth stage.
Thereafter, your lordship, as
Definitely
per RBI
affect
instructions,
the
we could not
yield of the
deposit
crop.
because they were,
Because of
DCCBs
such
were
exclusion,
told not to take
the
our
paddy growing farmers who account for
SBNs,
more
your
than
lordship.
95%
And that is why we could not
of
deposit.
the
So my first
insured
submission is,
farmers are
despite our
deprived of
best
the
efforts, we
benefits
could not
of
deposit
the
the amount.
Pradhan
Yes,
Mantri
yes,
Fasal Bima
my
Yojana.
learned friend said
As the matter has been
yesterday that we
discussed
were given
during
opportunity and
sixth national
we
level
could have
monitoring
opened our
committee
accounts in some other banks. Your lordship.
meeting,
We were not
I
allowed to
urge
do
upon the
that.
government
So my
to
submission
make
is, your lordship,
appropriate
even if your
changes
lordship is
in
de-tagging
the
the amount,
operational
there are
guidelines of Pradhan Mantri Fasal Bima
and
Yojana.
there are IAs also, which has to be taken into consideration, your lordship.
आपको मैं दूंगा
And
मौका
there should be a
भेजे,
general
आपने
order.
बोल दिया
My
सदन
submission is
व्यवस्था
this.
दी,
All
दूंगा
right.
मौका
Like,
Yes, where is the party in person?
मेरी लोकसभा के अंदर सबसे
You want
ज्यादा
to-
मायने है
There is this order of this honorable court in this particular matter only, in which NABARD was directed to go and.
तो मैं आपके माध्यम से माननीय मंत्री जी से प्रार्थना करना चाहता हूं कि लाखों की संख्या में वहां मजदूर काम करता है माइनिंग के अंदर, लेकिन हर रोज बीमारियां बड़ी तेजी से बढ़ रही हैं, दुर्घटनाएं भी
They have
बढ़
not
रही
come.
हैं।
My
तो ईएसआई हॉस्पिटल जहां जहां या तीनों जगह जो क्षेत्र भिवानी जिले में, बादरी में और नारनौल में पड़ते हैं, वहां पर तीनों जगह
I have submitted a written submission on this issue, Your Honor, in my petition. My banker denied an opportunity to me to make deposit into my bank.
That you have said, no, already you have said. All right, sir, all right. Next, yes, where is the party in person?
किसानों की जमीन का अभी तक पूरी तरह से मुआवजा भी नहीं।
Yes, Mr. Sharma, Viplav Sharma.
Lordship, please, Maharaj.
मेरे लोकसभा क्षेत्र
Tell us.
Maharaj,
Be brief.
Very
It's only a
brief.
rejoinder. Be very, should be very brief.
Yes, Lordship. Maharaj, the first thing first is, if your Lordship sees knowledge, as of present, the stand of the Union of India's knowledge is what was done by them in the previous government was constitutional and righteous, and it was done considering the policy benefit for the whole of the welfare of the country. So, Maharaj, if that be so, Maharaj, and if that contention of theirs is held, which Maharaj, I'll assist your Lordship and my senior colleagues have already assisted your Lordship, on the parameters of the law and etc. So therefore, what they did was right, and they have a right to do it again and again, whichever government comes in. Now, the consequences of this, my lord, says that what has happened is in respect of the currency, which is, my lords, inextricably linked with all the citizens of the country, my lords. So therefore, anything and everything, whatever has been done or possibly would be done after, my lords, whatever judgment your lordship will be pleased to, my lords, deliver, will have a, my lords, far-reaching consequences in times to come. So therefore, my respectful submission is this, my lords, that the notification which was issued on 8th November, my lords, that was in respect of, if your lordship has, my lords, heard submissions for small days, is in respect of 26(2), which, my lords, provided the central government, my lords, authority on the basis of the recommendation of RBI to declare a particular any series of currency of any denomination to be no longer a legal tender. Now, my lords, my respectful submission, what I'm trying to draw a little distinction is the whole the issue of currency and the nature of denomination of the currency is distinct and different. With my respectful submission, my lords, the currency of the country is a rupee, and it is 1 rupee, and that's why, if your lordship would see, it is printed as a coin, and it doesn't have any my lords, promissory declaration on the coin. So that is the currency. So the currency did not get demonetized. It was the negotiable instrument which starts from, my lords, in terms of the RBI Act, which has authority to, my lords, print the negotiable instrument act in the denominations of various denominations, 2, 5, 10, 100, 500, so on and so forth. Now, my lords, therefore, if your lordship, my lords, I'm just, your lordship would be knowing it, but the promise which is made by the Reserve Bank of India is written on the each negotiable. My lords, I'll just take your lordships to. It says, I'm reading out one of the currency which I have, my lords, 500 rupee note. My lords, it says, I promise to pay the bearer of the sum of 500 rupees. So it is that rupees which is the currency of the country, which, my lords, the Reserve Bank of India doesn't have authority to, my lords, print or mint. It is only done by the Ministry of Finance, and that's the reason, my lords, the Secretary of the Finance has a, my lords, signature to authorize the minting of that rupee. So what my respectful submission is that demonetization of the rupee did not take place. The negotiable instrument which was printed by the Reserve Bank of India in a particular denomination got declared to be no legal tender. So that would not mean, because it's a statutory, as my colleague Mr. Diwan has argued in length.
Mr. Sharma, all these points have already been argued. What do you want to say in reply? Tell us, directly come to the point. All these arguments have already been made, you know.
Yes, my lords, what I'm
You
saying.
also made this argument.
Yes, my lords. My lords, I would not.
What is there in reply if you...
Lordship, what I'm saying, there are 3-4 points which I'd like your lordship to
discuss. Come to the point. What point you want?
Yes, my lords. As regards to the first, just for the records, my lords, as regards the any series, any denomination point, my lords, that your lordship will find in my petition expressly urged by for your lordships, my lords, and it is in ground, my lords. I tell your lordship, the grounds is, lordship, can you make a note? It's ground H and I.
All right.
This is specifically urged, though possibly what petition which Chidambaram argued, writ petition number 916, maybe it is not specifically, but it is contained in my words, writ petition specifically, ground H. Then, my lords, I have to say, my lords, that 26(2) has to be tested on the touchstone of the whole scheme of the RBI.
That is also argued. It was argued at length.
No, my lords,
Don't repeat in reply. Yes.
This argument, my lords, trying to tell your lordship a different point. What I'm saying is, if your lordship will kindly consider section 17 of the RBI Act, so it basically provides two facets, that section 17. Now, it provides whole of the banking, which involves the money in terms of, my lords, the denomination which is there, and the banking
Sir,
and
Honorable
banking
Speaker, sir.
related money transactions.
The
The
widening
whole of the
and
section 17
development
is very
project of
elaborative. It talks about
NH66
how
in Kerala
the physical
has been
operation of the country
progressing.
will be manned
I have
in
some
terms of section
important
17.
concerns of
And
people
that
from
section
project
17 also
location
provides
to
that
convey
it will be
in
also the
front
duty
of
of the Reserve Bank of
Honorable
India
Minister
to
Nitin
manage,
Gadkari
print
and
the currency.
Ministry
And
of Road
accordingly,
Transport and
26.1 and
Highways.
26.2
There
is also there, and 24
genuine
is there,
concern
printing
of
and
people in
giving us
Charakan
legal status
regarding
also. So the point I'm trying
proposed
to make it
underpass
is, the
facilities
minute that
in
notification
Punnapura
came in,
Manappala in
the
Guruvayur
whole of
Assembly
the section
constituency.
17, operation of the
The
whole of the section
proposed
17 was
project plan
rendered
has
otious.
a vehicle
That's what I'm
underpass
trying to
of
suggest,
just
Your Lordship.
25
Because the whole
meters.
banking got
It is not
haywire. There
practical
are
in a
various
place
RBI
like
notification to the effect which I have placed
which
on my
is
record, and there are various
highly
other
populated.
petitioners who have also placed
Considering the
that
importance of pilgrim Sundays
the
like
whole banking could not
Manappala
take place
Juma Masjid, which is
on
one
Sharma,
of
what do you
oldest
want?
in the
What do you
country
want to
and
say?
very
So what I'm
famous
saying is that
We are not.
Sri Temple
What is
and
that you want
Bangalore
to
Church, which is
convey?
one of the
point I'm trying
oldest
to make it
church in
is
India.
that
Sharma,
This
all these
region
questions have already
shall
been
be
argued.
let's
provided
Please close.
more convenient project plan.
You are in
A
rejoinder. Please
flyover
close.
okay, Malaj.
with
Then
pillar
second thing
and
is that
wider
on the
underpass shall be
notification
provided
issue,
in
Your Lordship
Manappala
was very
Junction. Otherwise,
specifically,
tourists
Malaj called
coming
upon
to
the
the
Union of
beach
Indian Attorney
tourism
General
hub of
on the
Chittoor
Malaj,
Chavaka,
the
the
constitutionality as
students
because
around
that
this
notification was
area and
not issued in the name of the President of
merchants
India under Article
will
77.
have to
The
suffer with
Attorney
the
General
All
has
right,
proper
that we have noted. Please proceed.
passage
no, what I'm
between
saying is that
Punnapura
AG
and
has not
Mattala.
responded to
I
Malaj,
would
Your Lordship's
like to
query.
All right, all right. We will ask the AG.
similar
Now you
request to
please
the
proceed.
ministry. An
Opportunity,
underpass
Malaj
shall
gone.
be provided
Then
in
Malaj may say,
Nandanam Center
then
facing existing
Lordship may kindly
PW
have my
road.
petition for me only one ground which I want to urge. Lordship may have page
And
36 for me. It's
Edamutam
only
Center in
one
Valapad Grama
submission, and
Panchayat
I'll be
we
done with that.
need a provision for an underpass to connect with the service roads, and there shall be
What I'm saying is, Malaj,
a
if I may be
provision
permitted
for
to read Malaj, few lines,
crossing
Malaj, for my
as well
grounds.
as service road in front of the
Read.
What
Edapadi
I'm
Juma
saying,
Masjid.
it's
I
ground L,
kindly
Malaj.
request to the
The
ministry to
demonetization of
consider
any
this
currency is
demand.
completely
I
beyond the
will
scope of
submit
Reserve Bank
a
of India
detailed propose regarding
Act
this.
34,
Thank you,
which is
sir.
relatable to entry 38, Reserve Bank of India of list 1, in list of the 7 schedule of the Constitution. The demonetization of any currency, which is as reported 86% in circulation in the whole country, by way of declaring the whole of such currency to be ceasing to be a legal tender, is completely outside the domain of the Reserve Bank
So
of India.
Sharma, this was repeatedly argued by many, by almost all learned advocates.
Malaj, my respectful submission is that the demonetization will take place under the Act of Parliament in terms of Malaj entry 38, not under in terms of that.
It has been argued by everyone, not once, but more than
Many times.
Malaj,
All right, all right. We will conclude. We will.
Malaj, may I seek your lordship indulgence to file my 2-3 page written submission?
All right, that we will permit you. We will permit you. All right.
And around 1,000 constructed houses and institutions have not been assigned building numbers by the
AG,
authorities
though
concerned.
after reply there is
As
no
per the
provision to
corporate
hear you,
regulations
but if you want to say
of
something, you can
2019,
take 2-3
the
minutes,
central
and
government
if you have to make, thereafter Gupta can respond, or one of you. Choice is yours.
Mr. Gupta wanted to say something first. I will try to conclude.
You can.
Milord, this question which has been raised today, Milord, I believe, Milord, it is not really necessary for us to go into it. But since it has been raised, Milord, let me try and answer it.
The central government converted 175 panchayats into urban panchayats.
Now, Milord,
and recently in the month of September 2022, the government has issued an order to
what has happened is,
further
in
66
1946 legislation and 1978 legislation, the second stage was not indicated.
in my constituency are not
Milord,
included.
presumably, Milord, on the understanding that when legal tender comes to an end, Section 34, which says in circulation, also, Milord, comes to an end. On that basis, Milord, it seems to us that the legislature did not provide what is in fact provided in Section 3. But, Milord, it is our submission that it is not necessary to have that confusion. That is why, this time around, they specifically put it in. They noticed it, and so they specifically, Milord.
in 1946,
Yes.
26A has been subsequently introduced.
That's correct. So therefore, Milord, to the extent 26A takes care of it, Milord, no difficulty.
1946.
Yes.
46. 1978 is not taken care of. So, my lord, it is my impression, my lord, that they must have been under the impression that on a correct reading of section 34, once it is withdrawn as legal tender, those guarantees and that liability goes because the notes are no longer in circulation. But in this case, my lord, we don't even need to go there.
No, that is not the way. What happened was, since there was a window provided for exchange, unless the liabilities get reflected in the books of the RBI, they could not have exchanged.
Yes.
Therefore, it continued.
No. So I understand, my lord, the submission that this is because there is a liability. Now, it does not necessarily have to be because of that. It can happen simply because the notification says that it will be exchanged. That's an independent obligation.
Though it ceases to have a status of a legal tender.
Yes.
In view of the provisions made in the notification.
Correct.
It has got till 30th of December, it could be exchanged.
It could be exchanged. That is enough. It is not necessary, my lord, to delve on the theoretical basis on which this notification.
In any case,
yes.
In view of the ordinance of 30th of December,
yes,
it ceases to have any status from
31st of December, my lord. No. So therefore, this question, my lord, by itself is not today very important. But, my lord, my learned friend would like to really submit, as far as I have understood, that because it was alive till 30th, therefore there was no sufficient time given. But, my lord, what we are forgetting here is, my lord, that the first notification itself said, do it by 30th.
Yeah, that is.
Yes.
And then it said, there are these subsequent conditions. That's all.
We relies on clause
9. Sub 9.
Clause 10.
9, my lord. Page 4.
Sorry, 9.
9, yes.
Clause 10 of the press information.
But, my lord, we have to start with the beginning of paragraph 2, which says that the specified banknotes held by a person other than banking companies may be exchanged at any issue office, etc. for a period up to and including 30th December, subject to following conditions. Now, my lord, what is the normal reaction of a citizen of this country when he faces this? If my lord, 9 is the governing, my lord, clause of this, my lord, paragraph, then please see, it will not stop with NRIs. It will not stop with NRIs who have left money in India and gone away. Every individual, my lord, who thinks he can make out a case that he was unable to deposit the money will come and say that a mandamus has to be given to enforce 9. The deadline will vanish forever for everybody.
Mr. Gupta, repeatedly Honorable Prime Minister's speech was...
My lord, I know, my lord. Now, my lord...
But can you just come to page 26?
Yes.
26, I think all this para 1, 2, 3 have to be read together. Just read that 2, 3 sentences.
I'm sorry,
in
my
the
lord.
compilation of...
Compilation
Notifications?
of Mr. Ivan. First compilation.
You can't open it from there. Give me the copy.
You have this.
First compilation containing all the notifications.
Yes. My lord, we've also given, that's why, my lord. My lord, your lordship is looking at page 26 of this compilation.
26, last sentence you read. Persons holding.
Yes.
Read 2, 3 sentences. Let us read together.
Yes, my lord. I'm just wondering what.
Persons holding.
Persons holding old notes.
Read.
In Malvinder Singh's compilation.
Read.
Persons holding old notes of 500 can deposit these notes in their bank or post office accounts from 10th November till close of banking hours on 30th December 2016 without any limit.
Next sentence
Yes.
also, very important.
Thus, you have 50 days to deposit your notes and there is no need to panic. 50 days.
Sentence.
Your money will remain yours. You need not to worry on this point, provided you follow the law.
All have to be read together. Perhaps.
Let's suppose you read it together. Suppose we read it all together. What is this assurance said? It has said that if you follow the instructions which have been given to you, then your money will remain safe. You will not lose anything.
50 days time, even the
50 days time. He has mentioned 50 days there. He has not said that I will give you enough time later on also, not just 50 days. But even if he had, Millard, this is a statutory notification. Now that statutory notification, there is no case which can be made out that there is some kind of a promissory estoppel that this statutory notification will be extended. What is the legal cause of action here? And Millard, I keep, my lord, asking myself, what would a person normally do? He can come back in February, but he can't come back in November. The cost of the ticket is the same. He has not written, my lord, we have checked. He has not made any, sent any mail during that period.
That you already said, Mr.
Yes, yes, my lord, those are facts. But here, my lord, what I am saying is that the notification itself had provided 30th of December, and what happened was a limited window of opportunity was opened, no doubt, but that opportunity, my lord, this legislation did not want to open it any further. So, my lord, Parliament did not want to open it any further. Not
Clause 2.
yes.
Of section 1 of section
To the
central government.
yes, but even the central government decided not, because, my lord, your lordship knows the climate of that time, my lord. There was a feeling, my lord, that some of the provisions were being misused. So if under those circumstances, the legislature and the central government did not want to open a larger window, my lord, there is nothing that can be said about that. Now,
No, but the parliament in its wisdom
yes,
had thought that there may be such class of persons and for such reasons as may be specified,
yes,
that the central government may need to give some kind of a relief.
correct, my lord, but the central government in its wisdom has thought that they won't.
Now, even now, this
Yes.
law is still there. Even now, central government.
Let's look at section 6, section 5 for a moment. The person who, contrary to the authority of law, has held those notes is today to be prosecuted if he comes up with notes. Look at section 5.
Then how do you deal with situation where that widow found some money after her husband died?
Lord, it's very difficult, my lord, to deal with every situation like this, my lord. Because if you question is, under that subsection 2,
Yes.
can the court, my lord, now give a mandamus, as my learned friend is asking for, to formulate a scheme? They are saying you formulate a scheme, we or central government, whatever. Formulate a scheme to give a very large class of person, which he says is huge, opportunity to hold on to submit notes even today. Now see section 5.
So this is for the central government to take a call.
It doesn't matter, my lord. I'm not, my lord, going on that.
Yes.
My learned friend will deal with it. But please look at section 5. My lord, I'm not going to, my lord, continue this submission. If my learned friend wishes to, my lord, say anything, my lord, he will. Section 5, prohibition on holding, transferring or receiving specified banknotes on and from the appointed date. No person shall knowingly or voluntarily hold, transfer or receive any specified banking notes. And then, my lord, certain exceptions. Then penalty. Whoever knowingly, willfully makes any declaration or statement, etc., which is materially false, etc. And 7, contravention of section 5. Whoever contravenes shall be punishable. Now, my lord, which citizen, my lord, can be encouraged to say today that I have held on to these notes in the hope that the Supreme Court of India will vary the law? It just cannot be. They are under a duty to look at the law and follow its, my lord, dictate. They, my lord, so therefore, my lord, this.
No, Mr.
Yes.
Gupta, before proceeding.
Yes.
Now we were talking of this 10th November till the closing of the bank hours on 30th December 2016.
Yes.
Then 50 days to deposit.
Yes.
Then your money will remain yours.
Yes. Yes.
Now this 50 days to deposit, because I'm not clear, I'm just.
Yes. Please.
Was there a limit to deposit the amount?
No.
Or any amount what you held could be deposited?
Any amount, you are free to deposit any amount.
On a single day, on a single day.
On a single day or on multiple days.
The account, KYC compliant.
KYC compliant account.
The limits are only on withdrawal of the amount.
Limits are only on withdrawal, and my learned friend Mr. Chidambaram was right. Up to 4,000 rupees could in fact be exchanged. By giving 4,000 rupees, you could get 4,000 rupees of new cash, but not in excess of that. The rest of it, my lord, will get credited to the account, KYC account, and you will be entitled to withdraw it in accordance with whatever be there.
Whatever guidelines were
in place at that point of time.
4,000, it was increased to 10,000 from.
And then 25,000, etc., etc.
There was no outer limit insofar as deposit is.
No outer limit whatsoever. And that is so even for the NRIs.
But anybody who has money beyond the known sources of income.
Right.
Not have deposit.
When
yes.
unlimited deposit,
Yes.
subject to invitation from the IT department.
But there has been. Millard, there has been. It has been followed up by income tax investigation.
My learned brother ads and ED.
I won't.
Why
I'm
they-
not commenting, Millard.
Deposits in other person's
Yes.
account.
Millard,
They made deposits in
consequence that you will face. So people would, Millard, only go to the bank and deposit such amount as they know that they are holding legitimate. They did. Some people got away with it also, Millard. But not everybody got away with it. The point is, Millard, that in law, all legitimate cash that you had could be exchanged up to 30th December. Guarantee. Beyond that, Millard, we didn't give any guarantee.
All right.
And Millard, the second thing which my learned friend says, eliminate the proviso in that notification,
Yes.
which is dated 30th December. He says that eliminate this proviso in relation to a particular class, namely NRIs who went abroad and left money in India in excess of 25,000. Now, Millard, on what principle of statutory interpretation are we going to read down this proviso to that limited extent? There is no provision, there is no principle of statutory interpretation by which this can be done. He is, Millard, saying that in equity, do it. Because there is such a case.
142, 142.
142, yes, Millard. Millard, I am not opposing your lordship's, Millard, exercise of powers under 142. In fact, each of the special cases which are before your lordship, if your lordship wishes to look at the facts, Millard, and take a decision, Millard, we can have nothing to say about that. So that's the next thing, Millard.
Yesterday you made a statement.
Yes.
That insofar as Mr. Diwan's client is concerned,
Yes.
he had not even made a representation to the
Never.
RBI.
Never, Millard. Not within that period. Millard, he came back and tried to, Millard, make an application under 4.2, but that was not received because it was not in the format.
All.
And he could have filed an appeal also if it was within 4.1. Millard, if it is not within 4.1, it is our contention that he could not have made an application. And Millard, I've already, Millard, made those submissions. So therefore, the proviso, Millard, cannot be read down as has been suggested. And the final thing is, Millard, the guardrails, Millard, submission that it is no longer possible to issue diktats. I agree. But guardrails to limit, Millard, the possibilities of economic policy making, Millard. Is that, Millard, part of our basic structure? That's not. And finally, Millard, my learned friend says that it is because your lordships withdrew the jurisdiction under Article 226 and brought all the matters to this honorable court, therefore the date should be reopened. Millard, I have not followed. 226 would have given him this relief. Your lordship has withdrawn it. So your lordships have the jurisdiction now to give that relief. Millard, the withdrawal is not a reason for suggesting that today there should be a scheme. It doesn't follow from the fact that your lordships withdrew it. Because the High Court's powers were there, now the Supreme Court's powers are there to exercise it. In fact, if anything, he gets a benefit by this withdrawal for two reasons. One, those persons who had come to court were given some kind of an assurance that sections 5, 6 and 7 of the Act will not be applied against them. And the second is that they have got 142. High Court could not have given them that relief. So, Millard, I do not see, Millard, why your lordship's order withdrawing all matters to this honorable court should be the basis on which a mandamus should now be issued giving Milord directions to have a scheme. Milord, and Milord, I'm quite alarmed that my learned friend thinks that there is a huge category of persons who are having a grievance, because that's not evident to us, because the number of complaints is very finite.
All right. Yes,
Yep, yep.
Attorney, you want to say something?
I shall be very brief, Your Lord. And I can't catch up with the speed and sound of my learned. I will wish you 3 points. If the clock had stopped with a notification, we would have all kinds of arguments on the legality, the limits of the notification. How do you read 26, 26.1, 26.2, cessation of liabilities, and so on and so forth. But as it has happened in this case, different from what happened in 46 and 1978, it has happened in 2 stages. The government, on a recommendation received from the RBI, issued a notification. Did not happen in 46 and 1978. And in the ordinance, when it says we want by way of abundant caution, the ordinance says in the preamble, to have clarity and finality on this question, we say we also deal with the question of liabilities. Anything said by way of abundant caution is not wrong. It only tries to clarify the position. You can't pick up an argument from there and say, look at what they're doing, and try to build an argument of interpretation on 26.1 and 26.2. I don't want to get into the question of 26.1 and 26. It's a built-in scheme. Built based on 26.1, 26.2 follows. So both are so integrally, intrinsically connected. I have the power to say this is legal tender. I have the power to say it will cease to be legal tender. The limitations are built in 26.2. We don't have to go beyond that at all.
Once it ceases to be a legal tender.
That's right. 34 is for a different purpose. As long as it remains a legal tender, during that period, what is the position of banks, RBI's banks of accounts? That's the only limited operation 34. But 26 is an overarching provision. It is not dwarfed by section 34. As long as 26 does not come into operation, 34 will remain.
Once it ceases to be a legal tender, then it ceases to be in the circle.
That's right. Before 26, I said yes, it dwarfs section 34 when 26 will invoke.
Except for
That's right.
period extended for exchange.
Exactly. It is built into it. I mean, whether you treat it on the basis of contract or not.
After 8th of November, it would be between 2 persons. The transaction will be invalid. It ceases to be a legal tender.
Absolutely.
The liberty is only granted to deposit it in the bank. With the bank, and that's
right.
Compliant.
That's right.
But Mr. Ramani could not have given an amount to Mr. Gupta after that period. Legally.
Guarantees not correct.
There's no private transaction.
Private transaction.
No private transaction.
Exactly.
So his argument that even after that, the private transactions could have been done on the.
You have to read it into 26.2 as if a fresh legal principle built into 26.2. I don't think you can do that.
That is what is the argument.
No, he didn't argue.
The second thing is about, I don't want to traverse again, this. The notification subsequently issued in pursuance of section 4, where the parliament said there can be a grace period. And when the grace period recognizes certain categories of persons, residents and then non-residents, will ordinarily carry cash and come back with cash. When my other friend says, no, here is a casus omniscience, right? The parliament omits, the notification omits a very important sections of people who go abroad for deriving your benefit of being an NRI. I mean, I wish we preserve the dignity argument to more precious cases. An NRI wishes to go abroad and wish to get a benefit of being an NRI, wish to derive a financial benefit. He doesn't want to lose that financial benefit. He says, oh, don't drop my dignity. I'll have a financial benefit. And you want to get a financial benefit, you are robbing my dignity. I think that's misconceived. There's no dignity involved in it at all. That's why it's important for us to say dignity is operates in an entirely different sphere. Your personal dignity is involved. Your privacy is involved. So when you try to extend this kind of argument, it simply breaks down. The virginity of the arguments breaks down. I say there's a limit to that. The last is about the Prime Minister's statement. So when the Prime Minister makes a statement, kindly look just one reading, I keep reading it again and again. Page 27, paragraph 9. I mean, there can't be an argument of estoppel on a statement like this. I wish there's an estoppel against.
That is only an aid for construction, perhaps. The speeches made in the parliament.
That's one way of looking at it. It was at a time when the notification to Section 4 has not come.
Oh.
So that's why the Prime Minister said there may be someone for some reason, means good reason, a legally acceptable reason, legitimate reason. Therefore, you want to say, I will not forgo my NRI benefit. Should the state step back and say, well, there is a very good reason for that. I should have accepted it. Therefore, it is no ground, no case can be made out on that. And finally, on my 3 points, my argument on paragraph 2.53, a lot of things have been muddled up. I don't wish to give back in the same coin. The argument is after the notification, if the parliament sits back and says, look here is the notification under 26(2). Parliament debates it. Parliament takes note of it. This is the first time I've seen that when a notification is referred to by Parliament, and therefore the Parliament, that's why I said very decidedly, the Parliament gives a stamp of approval to it. I did not say it's a validating legislation. I understand the difference between validating legislation and the Parliament validating it by looking at it. Therefore, a considerable thought process has gone into Parliament when say, I look at the notification. The Parliament could have need not have referred to the notification. Need not have. But when the Parliament refers to it, you'll have to attach some importance to Parliament looking at the notification. Will you completely efface it out? My answer would be no. That's about all. Lordship, please.
And Mr. Jaydeep Gupta, we are reserving the judgment number 1. We are granting you time, whoever wants to file written submissions within 2 days. But please pass on the records if you have right now, both of you, if you have the records. Or else by today evening, you can submit the records.
Yeah, I'll put it.
Whatever. It is a perusal of the court.
Certainly.
For the perusal of the court.
Certainly, sir.
If it is readily available, give it now.
I will have it arranged.
Or by evening, you can.
I will have it.
You can give it.
I will.
For our perusal.
Certainly.
If you want, you put it in a cover.
I'll put it in a seal. I'll do.
You can put it. Both of you, please give the record, whatever records you have.
Only one small thing. The affidavits are virtually captured to a large extent.
No, let us have the satisfaction.
No, I'm not saying no. I will be saying that, yes, your lordships may have look into it.
Yes.
And it may aid, probably it may aid.
Yes.
Whatever arguments have been placed for your lordships. I'll certainly do it.
Do it. Thank you so much.
Lordship,
Liko.
Lordship, please, Lordships in 501.5.
Just 1 second, sir. 1 second. Just 1 second. Mr. Sharma, ML Sharma, what do you want to say?
I want to say only, I want to take 1 minute of the court, only 1 minute, Your Lordship.
Take.
Your Lordship, the entire issue is confined to the decision of the President. That's
All
what
right.
I have
Don't
challenged.
repeat all those things.
I will not, no, I will not repeat. No, Your Lordship, I will never repeat. That's my undertaking. And that answer AG has not given yet, and they should give.
All right.
I wish to give only 2 citations in response to this.
because Article 1110 is much.
All right.
Now he's answering your.
Yes, sir. At
The first one is
With permission, my lord.
1975.
With permission, my lord, I am taking only 30 seconds, my lord. My
Wait,
case
sir.
is this,
Wait,
my
sir.
lord.
Wait 1 second. Wait second.
1975, one SEC.
Sanjeev Naidu.
This is, no, Sanjeev Naidu it comes a little later. 763, one SEC 763. Then the next one is 2003, 6 SEC 277. Both are in respect to the Article 77 argument. They made that argument. But as far as 110 arguments concerned, I think it's misconceived. It doesn't warrant a response.
All right.
In my
What
case,
about the Article 110?
All right, sir. All right. We will
in my
consider.
case, my lord, applicant father was died due to sudden announcement.
We have understood. We have understood.
In my, I'm taking only 30 seconds, my lord.
Huh.
Applicant father was died due to sudden announcement, my lord. Thereafter, whatever money is received by the LR, they deposit in an account and they are facing the prosecution, my lord. This is the case, my lord. And if the announcement is not supporting the law, then we are entitled for compensation, my lord.
All right, sir. All right. Now you're right. Now over. Now you're right. All right.
Lordships, we had submitted that our money was lying deposited in the court before the MM in Rohini. And however, despite several applications filed before the MM, he did not release the money.
Sir, we have told you all these factual aspects will be, have to be decided after we answer these questions. We are not deciding factual aspects. We have been repeatedly telling you.
Lordship.
Over.
On the written submission, Lordship can give time till Monday.
No, sir. We can't. Give it by Saturday.
All right. Sorry.
Heard, judgment reserved. Written submissions, if any, on or before Saturday date. What is the date? Saturday? Give the date.
10th December.
10th December. Learned Council representing the respondent Union of India and Reserve Bank of India are directed to produce the relevant records.
Your Lordship, I put it in a sealed cover. I'm grateful to your Lordship.
Thank you so much. You have learnt a lot. Very champion is not here. Please convey our.
In fact, Mr. Chidambaram read out some passages from Mr. Rangarajan's book. I told him that I've also read that book. There's something which I can cite. I don't want to trouble your Lordship more with that book.
All right. Thank you so much.
सम्मानित कांग्रेस अध्यक्ष मल्लिकार्जुन खड़गे जी का स्वागत करेंगे।
एक मिनट, सब लोग शांत रहें, सब लोग शांत रहें, सब लोग शांत रहें। आदरणीय साथियों, अब अपने नेता आदरणीय राहुल गांधी जी आपके सामने मंच पर पहुंच गए हैं। अब एक भी व्यक्ति यहां से उठने की कोशिश नहीं करे। मेरा निवेदन है, अब मैं आदरणीय हमारे नेता आदरणीय राहुल गांधी जी और मल्लिकार्जुन खड़गे साहब से, जो कि हमारे राष्ट्रीय अध्यक्ष है, अनुरोध करूंगा कि वो बाबा साहब अम्बेडकर के चित्र पर माल्यार्पण करे। आदरणीय राहुल गांधी जी और मल्लिकार्जुन खड़गे साहब वहां पर फूलमाला करेंगे।
बाबा साहेब अम्बेडकर की इस पवित्र धरती पे हमारे नेता राहुल गांधी जी का स्वागत है, मल्लिकार्जुन खड़गे साहब का स्वागत है, हमारे नेता कमलनाथ जी का स्वागत है, भूपेश बघेल जी का स्वागत है।
दो छोटे छोटे। अब सब लोग शांत रहें, कोई हो हल्ला नहीं करेगा। सब लोग शांत रहें और कोई भी अब अपने जगह से नहीं हिले। एक मिनट बस, आप मैं 1 मिनट का कार्यक्रम, 1 मिनट में कर लूं, फिर आप करना। अरे 1 मिनट तो रुक जाओ। अब आपके सामने जो आदरणीय राजीव गांधी जी ने पंचायती राज 72वें और 73वें संविधान संशोधन करके पंचायती राज को जो मजबूत करा, उसी के तारतम्य में हमारी 3 जिला पंचायत के सदस्य आदरणीय राहुल जी का सम्मान करेंगे। कन्हैयालाल जी ठाकुर जी, रुक्मणी जी और रूमा भूरू भाई, जल्दी आइए। एक मिनट। साथ ही एक मेमेंटो जो हमारे सदाशिव यादव, यदुनंदन पाटीदार, जगदीश यादव, एहसान पटेल जी, एक मेमेंटो जल्दी से भेंट कर दे। और साथ में हमारे पोते आदरणीय भाई आर्यमन,
मैं सभी से आग्रह करूंगा कि स्वागत के बाद कृपया मंच से उतर जाएं। सभी साथियों से आग्रह है, कृपया मंच से कृपया उतर जाएं। मैं आदरणीय कमलनाथ जी से आग्रह करूंगा